Hello, hello, hello. Whew. All right, you guys. So I'm so glad to see everybody here. Thank you so much for being here. I appreciate the support so much. If you haven't done so, please do me a favor, give your girl a thumbs up on the stream. I want to get right into it because there's a lot to discuss, and I want to get right into it. Now, what I will say is, when I share the screen, which I'm doing right now, the audio in the very beginning is not 100% great. In fact, it's kind of poor, and I really, really hope that by the time the trial comes up, right, that it's fixed, because it's an issue, and it's kind of driving me a little, and I also hope that they get a different camera person, because I can't take the fast zooms. It's too much. Thank you guys so very, very much. I appreciate that. I'm glad you guys are enjoying the intros and the outros. As you know, I still get quite a bit of a rash of smack talking, usually in the comment sections after the fact, but whatevs, it is what it is. It's not going to change. The intro is the intro, and I only do it for lives. I know how to make a quickie intro for videos, so there you have it. Okay, so, and Kat says, lurking in the shadows while getting my 5th chemo and blood transfusion. Jen Lu, you are the best. Kat, you are the best, and thank you so much for being here, and good luck with the chemo. I know you're going to kick ass and take names, so there you go. Good luck, babe. All right, now, this is what happened, and this was very confusing for me, and obviously Sarah Boone, because she was unclear why they were there today. Now, why I find this to be, it's funny, but it's not, it's actually kind of sad. So at the same time, right? I can find the humor in it, but at the end of the day, it is sad because this is Sarah's motion. That there's a hearing today because Sarah made a motion, an oral motion. She does not want the media viewing her looking at the discovery. She doesn't want that, or no, I shouldn't say the discovery. She doesn't want the media to be allowed in the courtroom while she is looking at the physical evidence. And the judge is going to say something at the end, which for a girl, for a 47-year-old mom of 4 that are grown now, I mean, who only has a good enough diploma to have said a couple of lives ago and made a suggestion similar to what the judge ends up saying at the end, kind of, I don't want to toot my own horn, but toot, toot. I mean, I'm glad that, because sometimes I wonder, like, am I seeing this in a mean way? Am I just being mean? And then when the judge is like, says the same thing that I said, then I feel like, okay, I'm on the right track. I'm not just being harsh, So there you have it. All right. So we're going to get started. Anyway, that's the gist of it. Sarah's big mad. She doesn't understand. She's not prepared, all the things. So here we go. And I can't really remember when it actually starts. Now, as you can see, she's been led over to counsel table. She's allowed now to sit at the table, and she's not going to be cuffed and all of the things. Let me just skip forward a little bit because I just wanted you guys to see that how she's being treated fairly and all the things. Now, there is a representative from the media there who's going to argue why all of this needs to happen, why the media should be allowed in.
Is to have Ms. Boone proceed first with anything that she'd like to tell me. I will hear from the state if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time. Okay? Yes, ma'am.
Have a seat back there.
Or wherever you feel most comfortable.
And just sit back there while
Okay, thank you.
until you're ready here.
Thank you, ma'am. All right, Ms. Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFTB and the Orlando Sentinel.
Yes.
Okay, so here's why Sarah, and to be fair, this is a little abrupt. What had happened was the Orlando WFTB and the Orlando Sentinel filed motions opposing the courtroom be closed. They wanted the media present, okay? And they did it on the 12th and the 13th, if I'm not mistaken. And I think there might have even been a motion filed that day on the 14th. Sarah obviously does not have access to the court's website, so she doesn't see these things. And so, that is, she's not wrong about this. Now, I will say, one of the things that I don't really appreciate with Sarah, and I find to be an irritant, is it's one thing to not understand courtroom etiquette because you just, it's not, you're not an attorney and you don't understand it. I get that. Okay. But when that's the situation, I would look to the professionals in the courtroom to see, okay, how am I supposed to behave? And she's been to enough of these hearings now as pro se, speaking for herself, and watched enough that she should understand that there's proper etiquette just in life and also in the courtroom. And one of the things is to address the judge as your honor, and also to say, when the judge addresses you and says, Ms. Boone, do you have anything to say? The correct response is, thank you, your honor. And then you say whatever it is you have to say. And she has horrible manners and for the courtroom. And I've heard her a couple of times say thank you to other people, But I just feel like just read the room, Sarah, pay attention to what's going on, and this will go maybe a little better for you. I don't know. Also, she's been in receipt of the JAC packet, which is available on the Orange County Clerk's website. If you search Sarah's name and you click her criminal case, you will find the entire packet is there. It's been uploaded online, so you can see what they give her as tools to be a pro se defendant. Also, she over the weekend, she met with her private investigator. All right, so she's up to speed on some things, and on some things she is not. Here we go.
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV. It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th. And the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th. And it reflects, it said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have copies. Oh, perfect. All right.
And I do apologize on the Sentinel one, but the e-portal was down for a little while, so while we attempted to file it yesterday, it actually got filed.
That's why I was saying it. The certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Yes, you did.
Thank you. Ms. Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
So she's going to read and all the things, but I want to say this. So
Also, some circuit court cases that I know are in the report that might be hard to find. I have extra copies of those. If anybody wants them.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them?
all right, so they're going to let Sarah read this, and she's going to, take her time or whatnot. I mean, she's got to read it. I'm not judging her. Hold on, but I do want to say something about the setup of the courtroom and the cameras. I think that when the trial actually gets underway, we're going to see a different setup. Obviously, it can't be the way that it is right now, because when they pan out, you can see the jury box. And so that's going to be an issue. I think they're going to do something a little bit different when it all is said and done, to keep the jury out of the view of the public and all of the things. So like right now, it's kind of, whatever, but at least, she's getting to sit at a table so she can actually, write and participate and whatnot. All right. So here we go.
One of my topics of discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that, I would have already had this and not had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing.
Okay, here's where the problem is. Sarah seemingly does not understand that when she objected to the media being present, that is an oral motion, number one, and it necessitated there being a hearing, which was explained to her, that they were going to have a hearing to discuss this specific motion amongst other things, okay? One of them being with the request that she made of the jail. Okay, so she's not prepared because she doesn't understand the process. But again, this is what happens when you don't heed a judge's warning. And to be fair, Judge Kranick and her previous judge, whose name escapes me right now, warned her. They warned her multiple times that continuing to act in the manner that she does, because it's not simply that she wrote letters. It is the contents of those letters. We've been over this 11 billion times. Wooten, thank you, Stephen H. I appreciate that. We've been over this 11 billion times. It is what it is. She was warned. She didn't heed the warnings. Sarah listens to respond. She doesn't listen to actually understand. And that is not going to serve her well, because she is already behind the 8 ball because she's not an attorney. So this is going to be a problem. All right, here we go. So now she's unprepared. And again, it's everybody else's fault. At the end of the day, she asked for the case law and she got the case law that same day. She could have taken that opportunity to read through the case law. Then she would have an idea about what was going on and what she needed to potentially argue, but she didn't. Instead, she's hyper-focused on things that in this moment pertaining to this hearing actually don't matter. All right, here we go.
It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission. You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The only thing that I was provided was the notice of provision of witness list from the state, and then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Okay. Ma'am, with regard to,
This judge is so incredibly patient with her.
This is the first time I'm seeing each one of these documents.
I understand that. They were filed August 12th, and unfortunately this morning, due to an issue with the e-portal,
I wouldn't have internet access anyway to receive those.
they were sent to you via US mail as
Day
well.
before yesterday?
Yes. So you're not wasting the court's time. You can feel free to review those at this time.
Yeah, so he's going to let her read. Thank you, 99 Problems, but Crime Ain't One, Jen. Thank you for becoming a YouTube member. I appreciate that. He is
I believe that
incredibly
those are the
patient.
circuit court opinions that are referenced in WFTV's motion.
Now,
which
what I
cite
say,
to the
WFTB,
Miami
I
Hill
meant to
versus
say
Lewis decision,
whatever, the
which is the
local channel.
controlling law on this matter.
He reminds me a lot of.
These are mine to take.
Yes, they're yours. They were given to you. He reminds me a lot of Judge Doro from the Brooks trial, who I thought she did an incredible job. She was very patient. She was straightforward. Her explanations were easy to understand for somebody who is representing themselves, who is not an attorney, does not have any education in the law. It's not like they were maybe a paralegal before, or they went to school to be an attorney, but they didn't pass the bar, something to that effect. You know, somebody who has zero experience in the legal field at all. I thought she did a fantastic job, and I think Judge Kranick is doing a fantastic job as well. Let's skip ahead while we watch Sarah read, because we don't need all
What
that
is it that you'd
business.
like to tell me?
Hold on.
I'm ready whenever the court is. There's only so much that I can do just not receiving these. I don't have any opportunity to look up any case law of my own in the meantime, so.
But that's not, see, this is the problem. That's not true. And she always starts out this way. She always starts out with, I didn't have an opportunity. This is your motion. And the fact of the matter is, I can't state this enough. A lot of the problem here isn't simply just that Sarah has no expertise or experience or knowledge of the legal field. It's not just that. Part of it, a huge part of it, is when the judge is explaining things to her, she is listening to respond and not listening to understand. Hey, MK Lynn, are you feeling bad? Hope you feel better. Oh, Charlie, thank you so much. What if Sarah refused to represent herself? Then what? She can't. So, okay, what she could do in theory is be passive. Let's say she was passive through all of this, right? She filed 0 motions. She filed 0 responses. What would then happen is court would proceed. The trial would proceed. She would be there on October 7th for jury, to pick the jury, right? If she then did not participate in jury selections, she can be found in contempt of court. There are a lot of, she can be in trouble for that, and I also think, he reminds me also a lot of Judge Werner, very patient, very professional, but also very, very to the point, unlike your girl here who gives Miss America answers. And thank you, by the way, Charlie, for the $10 super sticker. I appreciate that so much. It was very, very generous. She would just basically be sanctioned. I mean, she can try to drag her feet on this, but they can try people in absentia if they don't know how to behave. So there's a lot of, the judge has options.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing?
You would think,
that's been
Victoria,
previously scheduled.
You would think.
My concerns, it is regarding.
So Victoria says, this is for the replay. Victoria Lee says, I knew about this hearing and what it was covering, and I didn't get the paperwork in the mail either. You think she would know from being there. Exactly. That's my point too. We all who've been watching this trial, or, watching these proceedings and waiting for this trial, we all knew what this hearing was about, right? I could have been prepared. You would have been prepared. Most of us would have been prepared. So, yeah. All right, here we go. Let me just go ahead and let's start again. I don't want to interrupt Sarah. Here we go.
Concerns regarding the September 3rd evidence viewing that's been previously scheduled.
My concerns, it is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court, other than sensationalism and exploitation, the purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. Again, my main concern is it is for exploitation purposes, which has already been greatly applied to my case in many, many ways globally again. And I see on the motion to intervene for WFTVs, my question is, why is this an important criminal proceeding? I don't. And why do they need to have it monitored? I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only It is my right to have some kind of privacy regarding my case. Nonetheless, it is an active case. And it's my understanding that some information is not able to be publicized due to privacy. And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only most important hearing that I would say that I have on the horizon. The press doesn't have a right to press themselves into everything in regards to my active criminal case. And I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I am asking for their admittance to be closed.
Okay.
This is an active, ongoing investigation case.
I'll try to find it, Nicole.
Anything else, Pam?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
Thank you, Your Honor.
You see?
I think Ms. Boone's argument really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the evidence and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence, but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as Your Honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. You know, careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis. If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been
I found
public.
it, you guys. Hold on. Let me pull it up for you. I found it. Let me share this other tab, okay? I got it for y'all. I knew it was Double Dare or something similar, so hold on. Let me get it for you. Let me see if I can change the quality. Let's see. That's as good as I can get it. All right, y'all ready? Here it is.
Hey, I'm here with Sarah and John, and they're psyched to go through that door into the video zone to battle Scortia. Now, you have 1 minute to get through all 3 levels. After the first 2, with the time left, you will go and battle Scortia in the wizard level. Now, for each level you get past, you will get a great prize. For each item you pick up, you will get $50. Here is your challenge. All right, into the zone there with you and extinguish Scortia's flames. Go through that door. Yeah. All right, Sarah's on her way. Flying along. That was a great time. Hey, she's up. Bam, there's 1 ring. She's staying low. All right, bam. Oh, she missed the ring at 40 seconds. She was down to 2 units of power. She got all of her power back now. Great. Bam, there's 2 rings at 32 seconds. Oh, at 28 seconds. All right, bam, 3 rings.
There y'all go. Hold on, let me. All right. Y'all ready? Let me share the screen. Y'all know I got you. I will find it. All right, let's finish listening to the to the attorney for the media. Here we go.
I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case, Your Honor.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor. First, I'm only asking for this 1 hearing, which is a very important hearing. I believe that the press is simply in it for ratings and publicity. My evidence is active, and I'm trying to salvage the little bit of anything that I have pertaining to my evidence that is not available online, which would be in that hearing. And I also heard she was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery.
Okay, yes, that was Sarah Boone in that video. She was on that show is after my time. My time on Nick was like Double Dare. And then the Toys R Us run. But yeah, that was Sarah in that video. I guess it's arcade something. I don't know. So yeah, that was Sarah. All right. Now, okay. I think where Sarah is mistaken is that while Sarah may have only recently received her discovery, the fact of the matter is this case, as she points out in many of her letters, is ongoing 5 years. And her discovery has been released multiple times to multiple different defense attorneys. And so I don't know that the clock, I'm not an attorney. This is something I'd have to look into for you guys. But if I can find her on some random Nickelodeon game show from 7 years ago, I'm pretty sure I can find the answer for you guys. But bottom line is, I don't think that the clock resets just because Sarah now has, now she's representing herself pro se. I don't think that's how that works, but I'm not sure, and I'll look into it for you guys. All right, let's go back to listen to her argument here.
She was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information. I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly. It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in regards to publicity, hostile, any type of emotion that you can come up with. I have received from Australia being the most recent. So I do not believe just because they would like to, again, in my opinion, for ratings and for publicity. It's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department. The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court. I would like to be able to properly prepare for this. Would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can free up the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am, Ms. Boone, you had the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied.
See, here's the deal. If you have evidence of the pretrial publicity hindering you getting the fair trial that you are entitled to under the Constitution of the United States and of Florida, what you should have done is brought those letters with you. That would have been fantastic. You can't, it sounds a little bit like Letitia Stout in her last response where she said, I have all of this evidence, but I'm going to show it to you later. You're kind of all out of later. This would have been now. It would have been the right time to bring this up. If you have those actual, if you have that, if that's available, then now would have been the time to bring it up. And if you guys hang on and hang out until the end of the stream, I have a part 2 of the game show for y'all to watch. All right, here we go.
The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
Judge,
Mr. J, yes, ma'am.
forgive me. When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th. You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not aware of, I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. to orally moved or tenaciously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out, to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said, I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
which I have yet to receive, and I was not instructed by anyone in the court that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
No, Sarah. I mean, come on. The judge explained this to you. This is now I don't even know how many times, probably 8, like the number of lawyers, you've been through, which, let's be fair, like 4 of those attorneys, they had a conflict. It had nothing to do with Sarah. So we're not going to say that she's been through 8, because that's not, I mean, it's accurate that she's been through 8, but only 4 of the 8 attorneys have withdrawn because of Sarah. The other 4 withdrew because of a conflict. That's not Sarah's fault. So she's been through 4 attorneys. This has been explained to her at this point, in my opinion anyway, ad nauseum. When you say that you don't want the press to be allowed at a hearing, that is you making a motion. And then the judge says, all right, well, because she asked last time, have you made a decision? And he said, no, I need to review the case law and I need to hear arguments. That would have been the clue. I just want to send the judge some kind of, I don't know, wine and cheese basket. I don't know, bless his heart. I mean, I know it's his job and everything, but she tests me and I'm not even dealing with her. I'm only watching her. I can choose not to watch her at any time. The judge has no choice. He has to watch her.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for. And that's clear in the order that was provided to you on the 9th as well. It says
No,
that we would have a
David,
hearing
it's not
today
live.
on the 14th.
Happening now. This happened
And when did I receive
yesterday.
this?
Well, that was orally told you on the 9th. The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically, on August 14th, 2024 at 1:30 p.m., a hearing will be held in Courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and that we would be addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with, I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
That's certainly your opinion that you're entitled to.
There's nothing he
Any
can
reason for
do.
Ms. Fugate to remain? State? Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No, Nightbot is not
Thank you,
a
ma'am.
real person.
All right. In addition to
Now
what
watch.
was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting.
Yes,
I wanna
Eddie,
hear about
that's
that,
really
sir.
her, babe. Yep, 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 yep.
We have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Okay. Now, in between the last time that we were in court, which was the 9th of August, and this hearing, which is August 14th, the state and Sarah Boone had a discussion, okay? And they reached an agreement about about how they were going to handle this evidence viewing, okay? And they're going to talk about it here in a minute, and Sarah knows this. And so to me, it feels like she is not prepared intentionally because they've already reached an agreement. So for her to say, well, I'm unprepared because I don't have access to the internet and I don't know what I'm doing and I didn't receive this and I didn't receive that because I'm supposed to be getting it through letters and I'm never sure if I'm supposed to respond orally or I'm supposed to respond in writing. I mean, technically, writing would be best, but also when you say I would object to the media being present after, look, this is how it went. If y'all don't remember, she asked if the media would be present when she was viewing her evidence. And the judge answered her, and she said that she would object to the media being present. And she said some other things. And it's been discussed twice before this. This is just, to me, it feels like she is, it's not that she's not, like some of the things that she's saying about, her being at a disadvantage, she's not wrong about it. But at the same time, it's kind of a moot point, and you'll see why in a minute. And then I want to know what you guys think.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County Jail.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed with that.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree, it has not been fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
When the defense attorney wants to do an evidence view, you typically go to where the evidence is stored and the law enforcement agency. He or she can bring an investigator, and an investigator will take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or herself. The CSI, who would be present as well, which is a crime scene investigator from the law enforcement agency, would be the person to manipulate the evidence on the cutting paper. And then you would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying each piece of the evidence, but a piece of clothing, with the front, with the back, you have the CSI turn it inside out, those sorts of things. And then it can be documented by the investigator with photography the investigator has. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so that there's no contamination from DNA testing. And this is basically how the process goes on with physical evidence. If If it gets opened, it'll get resealed by the CSI right there in front of all of us. And the CSI will reseal the tape, re-put his or her initials over it with the new date. So everybody will be on the same page about why it was open, when it was open, so on and so forth.
Thank you for that. If I may, is it closed or is it open to?
No. People that are not involved with the case will not be there.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be photographed and physically examined. But in order for it to be turned on, it would have to be done at a different location where there's something called a Faraday box or a room where electronic signals cannot come in or out.
Do I need to write a motion for that?
For what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So, like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner, and then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by law.
Thank you, I'm grateful.
Welcome.
Okay. All right. Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay. So then is it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay. So then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3. If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought and viewed.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras in the court.
Okay. All right. Fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was?
Of course.
Okay. And then once that's provided to the court, it can be filed and then the court will cancel the September 3rd hearing. Yes, ma'am.
And that is done by the state?
The state will prepare
Provide
it.
the documents and bring them.
Yes, ma'am. The state will prepare it. All you need to do is just review it and sign it.
Thank you.
Okay. All right. Thank you, Mr. J, for providing an alternative solution.
I have to say, Mr. J coming in as for the state, sitting next to, I guess I don't know who's lead counsel on this because it was Mr. Cacciatore's case, but this is what. So we're going to talk about this phone situation. No, W, we're getting there. We're going to get to the jailhouse part. Just this, it's right after that. It's right after this. Okay. So we're almost there. All right. So there's been a lot of scuttlebutt about why does Sarah want her phone? Is there something that she thinks that she can access on that phone that they don't have access to? Well, I don't know what Sarah thinks. The fact of the matter is the contents of the phone have been downloaded. There is a Cellbrite report. Okay. And so I don't know if Sarah quite understands what that is exactly, but she does have access to it. She has access to the report. She has access to the data, all of that stuff. So if she doesn't know now, she will know soon. My personal thought on what does Sarah want on that phone is, I think what she wants is her contact list. You know, I think that there are people that she may want to speak to and potentially call as witnesses that are in her phone that she has, you know, not had access to for quite some time. And so she doesn't remember the phone numbers. And I think that that is what she is wanting to get from that phone, because there is nothing on that phone that the state doesn't have a copy of in some way, shape, or form. Okay, I do believe Lil Red says, I wish they would provide her the rules of evidence and procedure for criminal proceedings in the state of Florida. It would help her. When I skimmed through the JAC packet for pro se defendants, I believe in that, included in that is the rules of criminal procedure. I kind of think that I saw that, but if it's not in there, I do agree that she should have that. She does definitely need to see those rules, you know, but unfortunately, Sarah, Little Red says she may need contact lists for witnesses. I think it's fair myself. You're right. It is fair. Unfortunately, the situation is that the phone has now become evidence in a case, in the criminal case against her. And so what she would need to do is she would need to hire her own expert witness who can also download the phone, extract things from the phone, okay, and or simply analyze the extraction already performed, either way or both, and then they would be able to provide her a contact list. I don't think that, you know, that's what your private investor, that is what your private investigator is supposed to do. If what is, if, so Lil Red says, if it is, it will help with the appeal denial. If the rules of evidence and criminal procedure are given to her, yeah, I mean, you know, it is true that it would, you know, I mean, listen, if Sarah is representing herself, okay, she has an excellent argument for ineffective assistance of counsel. However, there have been cases where there's been an actual attorney and yet still an ineffective assistance of counsel appeal is really a difficult appeal to mount. It's rarely successful, although I think in this or under these circumstances, it probably would be granted. I really do. I think that, you know, being pro se is absolutely, you know, what it would be ineffective assistance of counsel. And I think that, again, you guys, they've spoken about making alternative arrangements to view the evidence that are that are not in open court, where the media would be granted access. And so for Sarah to get up there and say, I wasn't prepared, I think she was intentionally unprepared because they had come to this resolution, the state and she, and that the judge would likely be amenable to that. And so I think that, you know, it is what it is. And this is an excellent point. The beautiful Bernice says she may have already done that with other lawyers. Remember, she was ready for court at one point. It may be with in her hard copies, and that's an excellent point. So that's the only reasonable explanation that I can come up with as far as what she may want the phone turned on for, is to be able to get her contact list. But I would also argue that it's likely there's a copy of her contact list somewhere. Jenny says pro se defendants are precluded from ineffective assistance of counsel argument. Yeah, you're right. But I think it depends on how they became pro se. For example, if she chose to be pro se, she would absolutely, definitely be precluded from making that argument. However, because that is not exactly the case here, I think that there might actually be a good argument for it. It all depends, on the interpretation of the statutes and the laws. So that's really what attorneys are good at, right? Is arguing the interpretation of the law. And that's, she's woefully unprepared in this moment. So I think the next thing they're going to get through it too is the jailhouse situation, these requests that she made of the jail. And, so it is what it is. There you go.
Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a stun cuff. I understand that a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay. So if you wear a skirt, as explained to you by Officer Barnett, the stun cuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking me was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
As Mr. Barnett or Officer Barnett explained at the last hearing, how the stun cuff is affixed to a person, it is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. Now, I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the stun cuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority, if not all, of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings in regards to all of them, basically, but recently the stun cuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants hiding the stun cuff, or a skirt with it being visible, or I am able to sit here at the council's table with leg chains on and no one is able to move except for here at the council's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so Ms. Boone is aware fully of what the options are with the I have gone through.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
We have gone through the entire clothing closet as well as our backup for what we have. As it stands right now, unless we have any donations in the size that have to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, well, we do have some shirts, but for in terms of skirts versus pants versus the dress, that is everything we have that would fit in this food size range. So I just wanted that to be aware so that if Ms. Boone is making any sort of decision, she understands the limitations in terms of what we have to be able to provide.
Okay. Ma'am, did you have the opportunity to hear what Ms. Click said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers.
8 pairs of pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Click regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can't always have someone externally bring something into me.
Absolutely, you can always have someone provide something in your personal property at the visitation center, which I described as across the street from the center. That is not, the public defender's office is in no way involved with that. It was put in your property and the corrections with transported property.
Yes, ma'am, thank you.
All right. Any other questions for her? All right. Can Ms. Click be excused?
Yes, thank you.
Thank you, ma'am.
All right, so here we have Sarah making an interesting wardrobe choice. I want to point something out here. I don't know if you guys can see it, but if you look at the screen where my mouse is pointing, the clicker, you see where you see this? This is the privacy skirting, and you can see it over here as well underneath Sarah. So at the end of the day, if you want, look, here's the deal, Sarah. This is real simple. This is not complicated, and you're really complicating things. You're asking what if the hearings have been live streamed. It doesn't actually really matter if they were live streamed or whether they were recorded and uploaded later. Once it hits the internet, it's hit the internet. It is what it is. Okay. I don't think that I don't think that your preference of a stun cuff or to be shackled is something that is, I suppose you could ask about it, during jury selection. I don't think it's a smart thing to ask about. But what I would say is this. My advice would be this: wear pants. They're not going to be able to really see you wearing the skirt anyway. So if you're trying to wear a skirt just because you miss wearing skirts or whatever, maybe save that for the day that the jury comes back. But for the entirety of the trial, just wear pants and make it easy on everybody. I don't understand what the deal is. I don't know if she were shackled, how they are going to handle sidebars because it's my understanding that they're talking about a box. The box being from the defense table to the prosecutor table up to the podium. I don't know if they will. I don't know. As it gets closer, we'll see. But my advice would just be, cut the BS, Sarah. Just wear pants for Pete's sake. It is not that big of a deal.
The
Okay.
next issue that I wanted to address was the review of the digital discovery. Ma'am, Mr. Lane was provided at our last hearing on the 9th, the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence, and digital transcripts of the depositions of Detectives Chelsea Copsell and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock. Did that meeting take place?
Did.
Okay. What was provided to you, if anything, at that meeting?
What he and I did.
What was provided to you?
What did he give you, Sarah?
What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay. All right. And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Not more than one.
Okay. Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay. You did not have any issues opening up any of those files?
I personally myself did not open all of them.
Okay. All right. Okay.
It's on our to-do list.
What did y'all do? I mean, I know we can't ask. We can ask. She's
Ma'am,
not going to answer, but
Mr.
she
Lane
shouldn't.
also
But
took
geez, Lou.
possession of
Excuse me.
the hard copies. Have those been provided to you?
They were waiting at the dorm for me upon my return of the last hearing.
Okay. And where are they currently?
They're located at my bunk area.
Okay. And what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay. All right. Are they in some type of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay. All right.
A resurrected
Do
rat.
you
That's
understand
a
that?
really good point.
You've told me that you live in the female dormitory with limited privacy.
Hang on just a second. Excuse me, Your Honor. So a resurrected wreck says, I can't help but wonder if she wants the jury to see the stun cuff. Remember, Sarah doesn't think she's the antagonist here. She sees herself as the heroic victim and thinks others see her that way. I actually sort of wondered the same thing too when I was listening to this last night. I wondered, why would she go against the grain? Why is it that she feels the need to wear a skirt? I understand, people have their preferences and their choice in fashion. However, one common thread throughout many of her arguments, regardless of what the argument is pertaining to, is basically that she doesn't think she can get a fair trial. So if the situation is, these are the things that we do, here's your options in this case to ensure that the jury isn't prejudiced, why would you intentionally ask to wear something so that the jury could see something that may be prejudicial? I don't understand it. It's the weird, she focuses on the weirdest things. I absolutely cannot figure out her thought process. And y'all, I have tried. All right, here we go. Let's keep going.
You understand by keeping those boxes there may be a risk as to other persons looking at them.
I don't have any other choice.
Okay, but you understand that risk exists.
Of course.
Okay. Do you understand that there's a risk that those items could disappear?
I understand.
Okay, all right.
Let me say this. Let me
And do you
stop right
understand
there.
that it's
I'm
your
sorry,
request and choice?
Your Honor. I don't mean to interrupt you, but here's the deal. I don't know that Sarah necessarily wanted the hard copies for the reasons that she said. Because if she did, then she would realize exactly what the judge is saying. Anytime she is not in that, in the dorm, in her cell, however you want to phrase it, whatever you want to call it, that that evidence is free. It's, anybody can look at it, anybody can go through it. She's not there, she can't see. Where the USB drive, the advantage to that is there's a checks and balance system. There is a record, a written record of when it was accessed, for how long was it accessed, which jail staff provided her the USB drive and the laptop, etc. So, there's a record of that. Whereas, again, with these, papers, there's no record and anybody can do anything that they want to at any time. And that is, sometimes I think Sarah requests things just to see if she can get them. Because that having the physical documents, if you're concerned about, I understand that you would want to be able to look at them at your leisure in the off times, when you're not allowed, when you don't have direct access to your USB drive and the laptop. I get that thinking. However, she's brought up the security and she's super worried about evidence being leaked and all of the things. And there's far less accountability with, just loose papers versus a USB drive. It's mind boggling to me. Okay.
To keep those documents in your possession.
I do, and I'm also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer also for an extra security measure.
Okay, all right. I see that we'd have Investigator Lane here. Sir, if you can come out. Madam Clerk's going to go ahead and swear you in.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Billy Lane, owner and chief investigator of Prison Break Investigations.
All right, thank you, sir. I did see that your notice that you provided regarding the.
All right, I'm just going to turn this down and let the closed captions tell the story. What My Oh My asks is, how much does a trial like this cost? Well, I don't know exactly how much a trial like this costs yet. There will be receipts turned in to the judge, and then the judge passes that on to the JAC, and they're the ones who actually pay for it. But I can tell you it's at least $10,000 right now, because this gentleman on the screen, Mr. Lane, who is the private investigator, was given $10,000 plus $1,000 for travel. So we're already at that point. And that's just since Sarah took over. I don't know what it would be until this point. It's going to be quite a bit. All right, here we go.
Of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not sure if that's permissible with the policies and procedures. If not, I'm going to try and schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Your Honor,
Thank you, sir. Appreciate you.
I want to.
Okay.
Hold on.
The next,
second.
ma'am, is your.
Okay, so they're going to go over the letter that I read to you guys, where she has multiple requests from the jail. And I cannot remember who asked this, because it's up there in the comments or whatever, and I just want to get to it really quickly and address it about Sarah's upbringing. The truth is, while I think that's an excellent idea, and I would be very interested in understanding how Sarah Boone came to be, there isn't a lot out there. And so maybe after all of this is over, there would be something out there, but there at this point there isn't. It just seems like Sarah's sort of out there floating on her own. I know that she has at least one brother, and that they don't have contact. I think that in the initial contact with police, the day that that George's body was discovered in the suitcase, I believe it's on the body cam footage. The detectives are speaking to her about family, and I think she has mentioned that she has actually two brothers, but I can't remember for sure. So I will feel comfortable saying that I know for sure she has one, because it's been talked about by Sarah and Miss Cashman in open court. So I kind of think that Sarah's just basically on her own. All right, here we go.
A representative
I'm
from
gonna rewind
the
it.
Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera,
Hold on.
whoever it is that may be appearing. All right, can he be released?
Yes.
All right, state.
Your Honor,
Thank you, sir. Appreciate you. Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail. I have a Administrative Sergeant De Jesus on the link.
Good afternoon, Judge. This is Captain Gina DiGiovanni with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie De Jesus with me.
All right, very good.
I also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant De Jesus, if you could please, I only see you, Captain. If Sergeant De Jesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie De Jesus.
Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do. And we can proceed with the 7 different items that she has requested. So if you want-
Actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m. This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m. and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes,
All right. Do you have any questions regarding that extension?
I do not,
Okay. Is that acceptable?
very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors. So there's at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why, other than the fact that the assumption could be made that it could be made into something other than a USB drive. And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know if I could have my hard copies. I'm unclear, other than those reasons why I cannot have those as well.
To the extent you're able to answer that question.
And I would just chip in that, obviously there's safety issues and you can definitely distinguish between, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem, it sounds like to me, is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of storing, inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way that may affect security, and it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
I'll spell that, Judge. Shevenell.
One more time, please.
Shevenell.
Thank you.
With regard to the third request is to a classroom, Captain DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her, and she can review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo. So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it is not the maximum dorm any longer.
That's correct.
And I'm unable to utilize the classroom for an hour or 2 per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion of the 2 classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have just for fresh air? How is that? I'm not understanding specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff and the facility, I can make the accommodation where I could put you in a single person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
Okay, I got to pause for fair use commentary. Obviously, Sarah, you're not the only person, which you're well aware of because you referenced how many people are in your dorm at any given time. And you're going to have to get a little to give a little. And when, you're given an explanation and the judge turns to you and says, do you have any further questions regarding this specific matter? And your question is why, even though the answer to the why has been given. It's about safety and security for everybody in the jail. You, the other inmates, and the staff. They cannot watch you all the days at all the times. You cannot have a dedicated officer to you. And that is basically what she's saying. And it's only going to go downhill from here, you guys. I want you to brace yourselves. I cannot remember exactly when it goes downhill, but it's about to. All right, here we go.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to Orange County Corrections Department. And if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified. And nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there in order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours?
Okay. Again, Sarah, you're missing the point of this. She just explained to you that essentially you're only moving to a single person cell, okay? You would still have and maintain the same rights in there as you would in your dorm. She's only offering to move you to a single cell so that you will have the privacy that you requested in your letter to the officer here, okay? It's not that deep and it's not that complicated. You're not going to be locked in there 24/7. She just explained that to you. Unless I misunderstood. And sometimes when Sarah asks these questions, I question myself. Did I mishear? Let's keep going.
Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this kind of this broad general question about alternatives.
Objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that. Regarding number 6, a word program. We've not had a pro se inmate, again, myself, that requested access to a word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we could make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone to make all necessary calls. Hold on, I'm turning the page. For my case to use in trial. I have no other way to contact anyone that is not collect, which incredibly, I believe that's diminishes. I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications. Number 8, discovery hard copies. It seems that Ms. Boone already has access to her hard copies. The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard. And we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards, but the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the 2 cases of paper discovery.
All right. Ma'am, do you have any questions regarding Captain Giovanni's and the Orange County Jail's position with regard to the earphones, headphones, internet usage, word processor, telephone, and the concern regarding the hard copies and it being a fire hazard?
I do, and I was also including number 3, the classroom utilization.
Oh my
I
gosh.
just want to make it clear and in open court that
I'm sorry, you guys. I have to pause. I'm already annoyed. And all she said was 2 words, I do. And already especially when she then said, and I want to go back to number 3. You've made the record. It's very clear, Sarah. You're mad. You disagree. You don't understand why you can't use the classroom, regardless of how many times it's been explained to you. At this point, I don't even think that if they utilized crayons and drew you a picture of why the answer is no, you would still be arguing it. You've been very clear, and you've made a very clear record. We all get it. You are big mad. You want to use the classroom. The end. Got it. She wants a word process. She wants like Microsoft Word uploaded to her computer, to her laptop, so that she can type instead of write. And she wants a printer to be able to print that out, which again, the issue with all of this is the amount of paper. They are only inmates for reasons that are not actually made by the jail. They're actually made by the fire marshal. They have said you can have X amount of papers in your jail, in your cell, in your dorm at any given time, because they're trying to prevent a fire hazard. It happens. People pull shenanigans. It is what it is. And again, if she were given a printer, then she would be already she's already got a ton of paperwork just in her hard copies of discovery she insists on having, which is her right. Then on top of that, she wants to print out all of these motions, and it's just a huge mess. All right, let me just play it.
I want to have the understanding with everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or my option to be moved. But I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security and potentially Ms. Boone.
Right. She's not telling you. Hold on, Sarah. Just a minute. She's not telling you that if you were to switch and be in a private cell in a different dorm, that you would be on lockdown 25/8. Okay, your rights and privileges go with you from Gen Pop over to that dorm, where you would be in a single cell. A cell for a single person, for Pete's sake. That's all she's saying. She's offering you privacy. But here you go. Let's ask some more questions that don't make any sense and are really unnecessary, because she thinks if she asks the question a different way, she's going to get a different answer. And it drives me nuts. Here we go.
Am I able to proceed?
You can.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access, if I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week, where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do so by having this, where I am confused why this was not all solidified prior to the implementation of the laptop. So I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott. I mean, I'll chip in with the legal piece. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above, what our typical stance is for pro se inmates. And all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's going to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, she's legally, she's allowed access to the court and all these other things that she wants. And really, and I'll tell you what the case law says. The case law says if she's pro se, she's entitled to get, a paper, a pencil, and some stamps and some envelopes and those types of things. The idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, she's gone through, I think, 8 attorneys in this case, and she had several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that
Not
question.
being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Oh, let me interject here, if I may, Sarah. There have been pro se people who've chosen to be pro se defendants in a criminal case going back 7 years, like forever ago. And there was no internet access. They had access to the law library. They had access to paper, pen, stamps, and envelopes, and that's it. And were they successful? Well, I don't know because I can't think of off the top of my head every single pro se defendant of all time. However, what I will tell you is, generally speaking, when you're going up against an attorney, which would be the state, you're probably not going to be successful being a pro se defendant just because you don't have the experience and the education. Simply put, I don't know that their lack of materials and access to a phone and a Word document program and a printer and any other things that you've asked for, I don't know that if they'd had those things, if they would have been successful. You know, the internet, unfettered access or reasonable access to a phone and a Word document, et cetera, is not a miracle. All right. Your case is what your case is. And it's that video that you have is damning. And instead of being focused on the stuff that actually isn't that big of a deal and actually won't really make a difference one way or the other, quite frankly, what you should be focusing on is how you're going to get around those two videos, because those will be played and those are going to be very, very difficult for you to overcome in the jury's eyes. That is all. Please continue.
Counselor, if you.
I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for one of the participants, sir. If you don't, you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
They're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
Yeah, I mean, Judge, like I said, we've got tons of pro se inmates that have come through. They're there right now that have come through the jail, and they get standard treatment. And she wants a lot of things that are over and above that. For instance, again, unfettered phone calls. She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that we could probably find plenty of examples, if need be, as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay, to answer what my question is, which two videos, the cell phone one where boyfriend's talking and what other one? There are actually two videos of George in the suitcase. One is longer than the other. And so that's the two videos that I am speaking of that I know for sure are going to be used against her because they were in her probable cause affidavit. So there are two videos. If there are more, I don't know about that. And there might be, who knows what all they extracted from her phone and are going to be using against her during the criminal case. But I think that the reason they used the two videos and referenced them in the probable cause affidavit is because those would have definitely secured them being able to charge and arrest her for George's murder. So what else they have, I don't know. Here we go.
Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument and what is being provided to you. With
They
regard
haven't
to
gotten there
internet,
yet,
word
Ash.
processor,
We're almost
and
there,
telephone,
though.
again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of an investigator, and JAC provided you $10,000 and $1,000 for travel for your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, he can do that for you. I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone, based on arguments of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter. If it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Yeah, it's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument, and authorized reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is the sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Ms. Boone's letter, if you give me one moment. In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag discreetly located at my bunk. I will purge the documents I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space. I'm willing to see what she's going to purge and send to property, but at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have here, along with the almost 100 or so assigned staff, civilian and certified.
Okay, so Lil Red says, in all fairness, we'd like to say innocent until proven guilty. She had a right to represent herself and should have tools available. I understand this is unpopular, but she is definitely at a disadvantage. No, I actually agree with you. She is innocent until proven guilty. She does have a right to represent herself, although she didn't actually exercise that right directly. You know, she didn't say, you know what, Your Honor, like Letitia Stout did. I think I'm better equipped to represent me than anybody on the planet, and that's exactly what I'd like to do. So, although it happened a little bit differently, she does have she should be able to have tools to prepare her case. However, she also she cannot, and they are not going to allow this. They're not going to allow the tools that she's requesting, which would level the playing field, as it were, a little bit. I mean, she's still going to be at a disadvantage because she's not educated in the law. That's just how it goes. But they have to balance giving her a Word document program, unfettered access to the telephone. You see, if they actually, I think what it is, truthfully, is even though it is a right, when you try to exercise that right to go pro se, the judge in your case will frequently remind you repeatedly why you might want to think it over. You might not want to do it this way. Because Sarah's right to represent herself also cannot impede on the jail's obligation to safely house people who are either in jail awaiting trial or serving out a sentence. So it's going to be a delicate balancing act. And again, if they were to acquiesce to each and every one of these things that she is asking for, what about other inmates? Then they could say, well, I'm going to fire my attorney and represent myself because I would like to have these same rights too. You see what I'm saying? It's a very, very slippery slope. And at the end of the day, the jail has a specific obligation, a legal one, that they can't, they're trying to protect themselves too from any potential lawsuits coming that could, be the result of something happening because a staff member is distracted by escorting Sarah to the classroom. You see what I'm saying? It's like a lot. All right, let's keep going. And they're trying to compromise with her too. So, I mean, there's something she isn't going to get. And that's just the way it is. She's in jail.
I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that, we may have to find an accommodation. And based on the willingness of the letter that Ms. Boone has written, she articulates clearly that she's willing to purge and send the property.
And this is probably the most excellent rebuttal and point to all of the being pro se. She wasn't ordered to be pro se. She can still hire her own attorney. Rita is exactly right. What she lost was her access to the public defender's office. She didn't lose her access to an attorney. She lost access to a public defender. That's what she lost access to.
Any paper that's over and above.
Do you have any questions? No, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did not know that they were fire retardant bags. I have the one already at my bunk, and I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well, because of the difficulties of receiving and delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting for this hearing to happen so I can figure out when to tell her to come to do so.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag, property bag, because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there, where I already have everything in the boxes in the one bag already being occupied.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure.
Okay, so this Tobacco says, I'm surprised her ad didn't get attention from an attorney who would do this pro bono. I think that by and large, the reason that the that nobody took her up on it is because the judge was very firm in his order on June 28th that there would not be a continuance granted or an extension granted to move the trial date out from October 7th due to an attorney's need to be able to prepare her case. And so I think a large part of the reasons why an attorney wouldn't take her case is due to the fact that it is a rather short time to prepare. And I feel like they wouldn't want to risk it. Also, not only would it be pro bono, okay, I would say that likely it wouldn't just be free. I think it would actually cost an attorney money to represent Sarah without any type of reimbursement. And then I think another reason why attorneys are hesitant to represent her has to do with what the other attorneys who filed motions to withdraw because of irreconcilable differences between them and Sarah cited. And one of those things was something having to do with something ethical. And I wouldn't want to get involved in that either. Now, I don't know. Obviously, they were never those attorneys that filed that requested to withdraw. They never went into specifics. They don't have to, but it does give one pause. And if I were an attorney, and that is something that was cited in the motion to withdraw by the other attorneys, it would give me huge pause. I am very, very curious about what exactly it is that they're referring to.
Are you, the procedure for having them stored and where they're kept is identified today? Is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Judge, may I say something here?
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those two boxes. And there is no way to organize or separate. So it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those two fire retardant bags with my hard copy discovery enclosed in those. If I could please do so.
Mr. Chivinell,
Captain Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may help her to separate her documents?
I could provide the third fire retardant bag, but it's the encroachment into another inmate's area. It's a limited space. But the cardboard box can't remain. And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this very reason.
And I understand that. And Ms. Boone has continued to request the paper copies. And that's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
That's up to her if she wants paper or not. That's fine.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless, it's being put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives.
Hold on a minute. Hold on.
Not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods.
Okay, here's the deal. Sarah, you have had access to the laptop and your USB drive since August 5th, okay? It is the 14th when this hearing was on the 14th. What are you doing in all of this time? What have you been doing? I don't understand. I mean, she's very well aware of how long she has to prepare for this trial, her defense. She's very well aware of specific deadlines for things that need to be filed. So what do you mean you haven't had time? All you got is time, ma'am.
When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk. I have that as plan B when plan A is closed.
Judge, if
Let me just say this really quick. Let me answer what my's question is. Who is the woman talking? The woman talking is the woman who is in charge at the jail. And this is who Sarah wrote and addressed. She's the captain. And she is the one who is going to address all of these requests that Sarah has made. That's who she is. So
I might be able to offer a resolution here. Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively had waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
Would Miss Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone,
It is a mass amount of paper.
are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet.
what
because
are
I'm
you
waiting
doing?
for, information for this, but I can further explore once I return back to the dorm.
I can provide.
Sarah, listen, this is what irritates me about Sarah. What have you been doing all of this time? You were adamant. She was adamant about getting her hard copies. She wanted that hard copy discovery. She did not, the USB drive is cool and the laptop is cool. I mean, I do need it to watch the videos. You can't watch videos on paper, blah, 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 right? She was but all she wanted was those hard copies. It has been a while since she's, received those, and she hasn't, oh my God, fully. Sarah.
Some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida model jail standards, to reduce the amount of paper clutter in all living spaces.
Oh my gosh.
It's not specific to just your housing unit.
Right. So basically, Sarah, the whole situation by offering you a cell for one, is to offer you privacy. It's not going to change the amount of paper that you can keep in your cell at any given time, because that is about safety. For Pete's sake.
Thank you.
Captain DiGiovanni, does that now can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or string.
Bruh, just take your
so
bags
that
and
she can get
hush.
everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are what becomes or is the fire risk, because it is not authorized or recognized as a, fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out.
You're just not going to
I'm
have
amenable,
unfettered
I'm
access to your
amenable
files,
to her
lady.
keeping her documentation. I'm not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
Yeah,
I understand.
put it in your
And
bags
I would
and move
be
along.
Happy to comply with the extra bag and the manila envelopes for separators in regards to that.
Yay.
So ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is, if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some.
You're not allowed to have
elastic,
that. They're
something
not
to
going
be
to
able
let you.
bind the paperwork together. Is that a possibility?
No.
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It's just a floppy bag. So
That's why
when
she's
pick
giving you
it
the
up,
manila
everything
folders.
goes in the middle. So there's no type of, there's no way of actually being able to make sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope, and that manila envelope keep the paper in order.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
Oh,
Ma'am, is that
is that
acceptable to you? And
everything?
is there
Come
anything else
on,
we need to
Sarah.
address
Let's
with
get
regards
this
to the
show
hard
on the
copies?
road. Don't you need to be going
Not in
over a
regards to hard copies, no.
discovery?
Okay, all right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Shebamel?
Yes.
Could you please provide me with the protocol or policy that you all have, a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet. Does Orange County provide something like that?
You'd have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
Yes, please.
You
Captain,
need to
I would be
hold on a minute.
responding to you in regards to that or following up with you.
Look, Sarah, this isn't all that complicated, okay? Obviously, jails have policies and procedures, and they're likely written and contained somewhere, okay? In a pamphlet, I don't know, in a binder, something of that sort. I don't think that they would require people who worked at the jail to know all of those policies and procedures by heart with no way to read them. Does that make sense to you? There's probably a procedure somewhere written down about what is allowed if you are a pro se defendant, what policy and procedures they have for that. That's all you need to ask. The way that you word questions, see, if you don't ask the right question, you ain't going to get the right answer, lady. Sheesh. It's all, I'm sure there's a policy and procedures handbook. That's what you need to be asking for.
Or Sergeant De Jesus?
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shabamel, you repeated that I have access to the court. Could you please define to me what your access to the court is for me?
They take you
I'm
to
not just a
court.
witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am,
Yes,
he's not
Kara,
in a
they
position to
do.
answer those questions.
Could you please answer who might be able to? Because I am in desperate need to view the case docket, which requires internet, and I am still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity and advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one.
Okay, Sarah, you need to stop right here, right now, okay? You were unprepared to fight against the media wanting to let me start again. You're unprepared to make an argument as to why the media shouldn't be allowed in the courtroom while you are viewing the state's physical evidence against you in your criminal case, which is a non-issue, which you also knew about because you brought it up. It's a non-issue. That's not even going to happen. You and the state have worked it out. It's not going to be held in open court. You don't have to view the physical evidence in your case in front of God and everybody globally, as you say. That's not going to happen. And every time the judge makes an order, he gives you a hard copy, mails you a copy, and instructs you orally. So you're unprepared and complaining about something that is ridiculous, in my opinion.
Way for every time that I'm here in the courtroom and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just.
Now, Sarah's not half as smart as she thinks she is, because I think there might actually be a loophole here. Sarah, I think, could file a motion requesting that she have access to the online court docket. I think what the jail is upset what their issue is that she's made an incredibly vague response. I need access to the internet, the whole internet, right? Which would never in 11 billion years be granted to her. Okay. However, she does have a tablet and she has gotten stuff digitally that way, notices of things. So I think all she would really need to do if she were actually listening would be to file a motion requesting access to the court docket. That's it. But she's not gonna, because she's she's gonna be big mad about the being mailed things. Here we go.
Make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
We're
Ma'am, for
aware.
the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am?
Yes, I have a motion that I would like to submit, please.
Okay. Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may, do you know why it was not approved prior when a supervisor was the one who delivered it to me?
Oh my
I
God.
have no information about even the amount of hard copies. I didn't even know that that came into the jail because my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shebamal.
Are they free to leave?
Yes, thank you.
State? All right, thank you all very much. Ma'am, you made reference to another motion or something else that you had.
Yes, I have a motion.
Okay, if you can hand it to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it and then I will.
They should call
Ma'am, give
Steve
me a
from
moment to take a
Blue's
look at
Clues
this.
and have him bust out the handy dandy notebook and draw her pictures of the explanations of things, because I think that's the only way she's going to get it. I think sometimes she chooses to be obtuse. Some of this stuff she doesn't understand, obviously, because she's not an attorney. But I think there's also an element there that she's being intentionally obtuse. Scott, imagine if the state laughs out loud as they read it. Can you imagine? All right, hang on a second. Let me skip forward a little bit. We don't.
States court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense. State, I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay. Ma'am, I can't have a hearing on this today. I will have to coordinate a hearing with JICS to have this heard because this is something that involves them.
Right.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Right, thank you.
So the court will file this in the court file and we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Just to confirm, please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
As identified in the court's order, that is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence, which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, state?
Nothing, state.
Ma'am, anything else?
No, Your Honor.
All right, we'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
Forgive me. In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail.
I can certainly advise him of that, or my office can. Sure. Okay, I understand. All right, just so for recap purposes, with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows. Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right, anything else? Anything else, ma'am?
No, Your Honor.
All right, thank you very much.
All right. So I can't remember where he said this or when he said it, but I know he said it in this hearing, and maybe I don't know, disassociated at some point. But basically what he told her is that you have a private investigator, and you can utilize the private investigator to do some of the things that you're asking. Now, let me show you all this. This is the motion she filed yesterday with the court. And I haven't even looked at this yet. Okay. You guys can see that? Great. Okay. Make it a little bit bigger. Motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of defense comes now, blah, blah, blah. All right. Reasonable fees for a neuropsychologist. These services include reviewing of documents and physical evidence, writing of reports, travel, and trial testimony as grounds. The defendant states the following. Defendant is charged, with second-degree murder. B, defendant has been adjudged indigent for costs. C, defendant has no income and cannot afford the service of a neuropsychologist. D, a genuine issue exists related to this case, which will require the assistance of an expert witness in the field of neuropsychology. E, defendant is without funds and does not have the ability to pay the costs associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee protection of her right to process and effective assistance of counsel. F, counsel has contacted neuropsychologist Dr. Hyman Einstein. G, defendant intends to engage the services of Dr. Hyman Einstein. Dr. Hyman Einstein graduated from the University of Chicago Division of Biological Sciences, the Pritzker School of Medicine in 1982. He works in Miami Beach, Florida, specializing in psychology. Defendant seeks permission to allocate funds for Dr. Hyman Einstein services at a rate of $300 per hour for all work performed on the case except travel time billed at $125 per hour, with an initial cap of $15,000 plus reimbursement for all reasonable and necessary related expenses, including but not limited to travel expenses, lodging, meals, mileage, postage, shipping, and document reproduction as a service provider with the JAC. Defendant cannot properly prepare for trial until expert analysis is complete. Defendant has attempted to request this evaluation through her previous appointed attorneys without success based on several factors, to include the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness of neuropsychologists to work the case, and the authorization of the JAC to pay for said neuropsychologist. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. A neuropsychologist that specializes in understanding the relationship between the brain and behavior. Given the complexity of the defendant's mental health history, it is critical to assess her cognitive functioning and mental state to determine how these factors may have influenced her actions. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully requests this honorable court in conclusion for payment of costs and and appointing psychologist to assist in the defendant in preparation of the defense. There's her oath. There's a certificate of service. There you have it. Now, this is, you guys all hung in there with me, and I appreciate that so much that I want to show you part 2 of Sarah's time on Nickelodeon. Did I add to the stream? No. All right, here we go, y'all. Let me rewind it a little bit. You ready? Here we go.
We're not worthy. Yes, we are. And we are back right now for round 2. I have Mark of the yellow team and Sarah of the red team going to play the face-off Crater Ranger. Now, remember, in this game, you have to maneuver your ATV over dangerous alien landscapes. You have to avoid craters and explosions and other pitfalls. The player
Oh, crap.
with
Hold
the
on.
highest score.
Let me go
at the
back
end of
5
the
seconds.
Game, you have to maneuver your ATV over dangerous alien landscapes. You have to avoid
I mean, that is very most definitely Sarah Boone, I think.
craters and explosions and other pitfalls. The player with the highest score at the end of 30 seconds by traveling the furthest will get 50 points and control of Mikey for round 2. In positions, please. Ready, set, go. Whoa, yellow team got snagged. Right now, it looks like red team has traveled the furthest so far, but we're only at the 22nd point. Score's pretty tight. They're accumulating points. Good driving going on. Good steering. Good maneuvering. This is going to be a close one. We're down to 10 seconds. Whoop, we just fell out of.
All right, there you guys go. There was Sarah Boone on Nickelodeon. I am going to do a little bit of research on what was in that letter, or excuse me, that motion. And I'll probably do another live. I don't know that it will be necessarily tonight. Because I know that ATS News has a live scheduled tonight because she was so gracious to be on my panel on the 6th anniversary of the murders of Shanann Watts, Bella Ann, Cece Watts, and Nico Watts on August 13th. She came to my panel, and so she's going to do her retrospective for the 6th anniversary on her channel tonight. And also Melissa Jade has a recap of the trial of Letitia Stout that she's doing tonight. And I'm sure my girl Allie at some point would probably go live. And so in order for me to be supportive of my girls, I probably won't be live tonight, but I will more than likely be live tomorrow night. So I haven't seen that yet. Lil Red says, did you see the book Chad read years ago that mimics what he did to JJ climbing on the cabinets? I haven't seen that yet. I've been kind of wrapped up in Boone, but I will definitely check that out. I want to thank you guys all for being here. Welcome to the new members. Oh, I forgot to thank you, Tess, for the $4.99 super sticker. Tess says, I realize I should just wait and watch these with you, Chen Lu and Chad. I get so frustrated with Sarah Boone, and commiserating alone isn't as fulfilling. Thanks. Thank you, babe. That was very generous. I appreciate that so much. I appreciate all of you guys for being here. And like I said, I probably won't be live tonight. However, I'll probably be in chats somewhere with the creators that I mentioned before, ATS News, Melissa Jade, and probably Allie. I'm going to play the intro. It has some flashes, so if you're sensitive to that, you might not want to watch. But anyway, thank you all for being here. Have a great rest of your afternoon, and I'll talk to y'all later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Finish her.
It's on the back of the
2 minutes later.
We all do a little math sometimes.